All right, we'll wait a couple moments here while the participants join into the webinar. Welcome to everybody. All right, we still have people joining, so I'm going to wait a couple minutes here. All right, let's go and get started. Welcome to today's innovation lecture presented by the Tsai Center for Law Science and Innovation at the SMU Dedman School of Law. My name is David Taylor, and along with Keith Robinson, I serve as a co-director of the Tsai Center. The Tsai Center is a research-focused academic center exploring how law and policy affect scientific research and discovery, as well as the development and commercialization of new technologies, which is what we're going to be focused on today. The Tsai Center presents educational programming, facilitates academic research, provides educational opportunities that engage students and the academic and business communities interested in law, science, and innovation. Today's innovation lecture is co-sponsored by SMU's Linda and Mitch Hart Institute for Technology, Innovation, and Entrepreneurship. This institute combines the innovative forces of SMU's Cox School of Business and Lyle School of Engineering. The two schools integrate their expertise, resources, and guidance to develop technology prototypes and create viable business plans. The Hart Institute advances SMU's vision to promote technology and entrepreneurship through 5 key components: business plan competition, entrepreneur in residence, graduate fellowships, faculty fellows, and technology transfer fund. Today's innovation lecture is also co-sponsored by the Caruth Institute for Entrepreneurship, which is at the SMU Cox School of Business. W.W. Caruth Jr. established the Caruth Institute in August 1970 to help people learn by doing, experience the pleasures, thrills, excitement, and satisfaction of building their own businesses, to learn that business consists of putting yourself in a position to be lucky, and learn to overcome every obstacle by your wits and intelligence, and to accept adversity as a learning experience. Today's innovation lecture will feature Josh Malone, who will tell a story of innovation and intrigue related to, of all things, water balloons. Let me introduce Josh. Josh holds a Bachelor of Science in Mechanical Engineering from the Colorado School of Mines. Following college, he worked in Dallas at Texas Instruments, first as a reliability test engineer, and then as a digital light processing, or DLP, process engineer. While at TI, Josh designed components, processes, and microelectromechanical systems, and he was named as an inventor on 7 US patents. But in 2006, he left TI to found his own inventing and consulting firm. He developed and marketed his own inventions, but he also helped others by designing a wireless water meter, a wireless electronic gaming device, medical grade oxygen meter, solar panel, gimbal, other inventions. During this time, he was named as an inventor on 4 US patents. Josh eventually invented a solution to the age-old problem of filling and sealing water balloons. He raised nearly $1 million on Kickstarter, developed a prototype, sold over 2 million units in his first year, and eventually automated his production. His invention, which he marketed as Bunch of Balloons, became the #1 selling summer toy. That, however, is not the whole story. As he will share with us today, he sought and obtained patents on his invention, and as it turns out, it's a good thing he did. Another company copied his technology and refused to stop infringing on his patents. The result was a costly legal battle that ultimately resulted in a $31 million judgment in his favor. He's now a full-time volunteer with an inventor advocacy organization called US Inventor. Before Josh begins his presentation, let me invite you to submit questions for Josh. You do that using the Q&A feature at the bottom of your screen on Zoom. Following the presentation, I will moderate a question and answer session. So with that, let me turn it over to Josh.
Thank you. Thanks for the intro, Professor, and it's a pleasure to join you for this remote virtual conference. But this is very convenient, so I can join you from 1,500 miles away in Northern Virginia. So yeah, I appreciate your introduction. It's really fascinating, the intersection of these disciplines engineering and business and entrepreneurship and law. I didn't really imagine that was the path I was headed down. But here I am. And so I'll just tell you my story, and then I think you'll find it interesting, maybe a little bit horrifying, but hopefully I don't think it'll discourage the young people out there that are going down this path. I think there's still a lot of hope and opportunity in this country. Just to get started here, advance, there we go. A little bit about my history. As you mentioned, I was at Texas Instruments for about a decade. I worked in the digital light processing department. That was really fascinating technology, really advancing the state of the art in the high tech space, making micro electromechanical mirrors of all things. And we were controlling, individually addressing millions of mirrors and getting them to cooperate. Reliability was a big responsibility I had, and I worked in a lot of areas there, and that was great. I grew up, kind of cut my teeth at Texas Instruments. Some of us refer to it as TI, as the Training Institute, because many small businesses and entrepreneurs launch out of there, and it was a great experience. But it did become a big business, and hit a point where I was feeling quite constrained. I had a lot of ideas. I was very interested in innovation and getting outside the box. And as the organization grew and the company grew, there wasn't really a lot of room and flexibility for that. So we had budgets, we had management, we had agendas, and if I thought it was a better way to do something, that didn't, that had to go through the bureaucracy. So I eventually had a lot of ideas on the side I wanted to, tinker around with and pursue. And one of them just captured me and it wouldn't go away. And I was feeling kind of like I was at a dead end in the corporate world. And I told my wife I really wanted to, pursue this product, consumer product, to bring it to market. And she was very supportive, and she understood kind of I needed to spread my wings and get out there. And she said, okay, well, that sounds great. And she was, I guess we had a little misunderstanding, because she was surprised when I came home 3 days later. I told her that I'd given my 2 weeks notice, and we were launching the business. But she, we came together on that, obviously, and we really counted the cost. We knew this was a big risk. We kind of viewed it as really a one shot. So we could invest, a substantial amount of our own savings and pursue this dream. And if it didn't work out, I could go back to get a regular paying job. And so I pursued this one idea I had for a digital paper cutter, and that was a device. So I had noticed it usually starts with a problem, or for an inventor, isn't there a better way, or there has to be a better way to do something. For me, it was watching people in my family, my wife, my mother-in-law, a lot of their friends were into card making and scrapbooking, and they would use, some of them would use scissors to cut shapes and letters out for decorating pages, and others were using these steel die. So they would have like a die punch for an alphabet. It'd be 26 different punches, lowercase, that gets you to 52, and then punctuation, there's another 10. And so they would have these suitcases, and that's just for one font. And they would have these suitcases and closets full of basically an industrial tool. And I noticed they're using, basically massive parallel processing in order to make a one-off item. So that just didn't seem like the right way to do it. So I said, is there a better way to do this? If this is a creative endeavor, can we make one-of-a-kind shapes? And so I came up with this electronic cutter tool. It basically shrunk down a vinyl sign cutter in a sense, and put all that into a small 5x5 box, and battery powered, and digital interface. And this was in 2006, so it was interesting, right in the beginning kind of the smartphone revolution. And then so there were some challenges technically to get that mechanism to fit into that space, but that product actually it went pretty well. I was able to get a working prototype and and take it to trade show and pitch it. I wanted to license as an inventor, an entrepreneur. My niche was creatively solving problems, and there were others that I thought would be better at manufacturing and distribution and things like that. And so that part of it was harder than I thought. It actually took 6 months to get the product reduced to practice and working prototypes. It took another 12 months to try to close a licensing deal. And that business side of it was much more challenging than I expected. I did eventually do a license with a company, and we sold some number of units over a period of 3 to 4 years. And I took the proceeds from that and came up with another invention. I came up with this make your own silly bands. So in 2010, about that time frame, about a decade ago, there was a huge fad about these shaped bracelets the kids were playing with. And I had the idea of making your own. So usually these were molded products where you had a limited selection. There was no uniqueness to us or individuality. So came up with a way to make your own. It's kind of a system where you could shape these things and bake them in the oven. They set in that shape. And that was interesting, but we totally missed the market, lost a lot of money. That was a major flop. So after all this, it was an amazing adventure. I dabbled in a whole lot of other things, and David mentioned some of those. Some of it entrepreneurial, some of it through consulting and other interesting projects. It was quite enjoyable. But after 7 years of not having a regular paycheck, it wasn't working out. We were basically at the end of the line and was ready to go back to the corporate job, and just had one last shot. And that's when I picked up on the water balloon problem. This had bothered me for many summers and many hot summers in Texas, where we would fill and tie thousands of water balloons as a family. And I was the one that was, I was like, we got to fill them before we play. And so, of course, the kids are, after 2 hours of filling and tying water balloons, they're kind of done with it. And so all that for like a 2-minute war, right? So I tinker around with a lot of different ways to solve this problem. And the one I ended up landing on is basically it's surprisingly simple. I have to be careful. I was quoted as saying it was obviously simple, and of course they came back later on when they challenged my patent and said, "Oh, it's obvious." So, but it is. I mean, some of the greatest inventions, and I'm geared towards this way. I want to simplify things, not complicate them. So here I put a small. In the original version, it was a small O-ring around the neck of the balloon, and I was able to find a way to get it to clinch the neck of the balloon and seal it, at least I thought, and then inserted a tube through it to open it up to try to get water in it. And then in the beginning, it was just one balloon, one tube, and one O-ring, and I wanted to get water in the other end of the water balloon and the other end of the tube. And so I was looking to connect it to a garden hose, so I got a cap that goes on the end of a hose, and I looked to connect it to the hose. And so I looked immediately, I thought there's room for a lot more tubes here. And so I went ahead and filled the end of the tube with holes. I ended up with 37 3mm holes in the end of this cap. And I filled them all with tubes, glued them in, balloons on the other end, took it out to the water hose and filled it up. And it was the eureka moment. It worked. It worked pretty well the first try. I made a slight adjustment, and the second try, it worked like magic. So at this point, I'm not going back to the corporate world. I want to take this to market. And so, filed for a patent, and then was looking for a way to bring it to market. And I decided to pursue Kickstarter. And so Kickstarter has been fantastic because, in the past you would have to, purchase mold and mold equipment and go into production and, produce several thousand or 100,000 units, and then put them in a store and then advertise and then see if people buy it. And there's this huge upfront investment and risk. And so with crowdfunding, you can check a lot of those boxes ahead of time. So I went and produced a small batch, made a video, and put it on Kickstarter. And that's everything changed by 3 hours into Kickstarter. We had blown through our initial goal of $10,000, and we ended up with raising almost $1 million, and with 21,000 backers that thought this was a good idea. So we offered one pack of bunch of balloons for a $15 pledge. And here's, let me see if I can hit this video. This is our original video from 2014. Oh, sorry.
You ready? Whoa, where'd you get all those? It's bunch of balloons. Let me show you. You just connect it to the hose, and then you turn on the water. They all fill up at once. When they're full, you just give it a shake, and they all fall off. They tie themselves? Yep, pretty cool, huh? Yeah.
Hi, I'm Josh Malone, inventor of Bunch of Balloons, the fastest and easiest way to make water balloons. My kids and I love water balloons. While I sat there for hours filling and tying, I tried to think of ways to make it faster and easier. With my kids' help, I developed and tested several different techniques and prototypes. And finally, a few months ago, I invented Bunch of Balloons. Bunch of Balloons fills and ties 100 water balloons in less than a minute. The design is now complete and we're ready for production. Let's see how much faster and easier Bunch of Balloons is. Which method can make the most balloons in 1 minute? The old-fashioned way, 6 balloons. Tie knot, 8 balloons. Zorbs, 10 balloons. But with Bunch of Balloons, you can make 100 water balloons in a minute. Which team do you want to be on? We will manufacture and ship orders to our earliest customers in just a few weeks. Please sign up for one of our rewards and be one of the first customers to enjoy the Bunch of Balloons advantage in your next water balloon war.
So that was our product release, our marketing. It was we had a $1,500 budget, and we went out and got millions of views and a lot of interest in the product. So wasn't super slick, but it really did the job. So I was fortunate that people appreciated it and got behind it. So at this point, we're moving forward. So I've got to fill these orders. It takes off at this point. So we went viral on the blog. So it was covered by Gizmodo and BuzzFeed and Huffington Post early on, and then after that it went on Good Morning America, and everyone it was unbelievable, the attention that my invention was getting, to where the Today Show flew me out to New York City. I had a water balloon fight in Times Square with Carson Daly, and so anyway, things are just going crazy. This is awesome. And, the retailers are looking, they want to buy, millions of units, and toy manufacturers approach me. And at this point, I'm kind of halfway to having a business already. I've got demand. I've got a pilot production facility. And so I kind of had a choice to make. Do I forge ahead and start a business of my own selling water balloons, or do I partner with one of these toy companies? Well, one toy company approached me and had a really great business and presentation. Many of them I talked to, there was a challenge, and a lot of inventors get to this point and they're like, I've solved it. Well, for me, there was a big problem still. That was, how do we manufacture this cost effectively and with enough quality and so forth. So there was a lot of labor involved in assembling this product. And so I knew that was one of the problems I needed to solve. And I talked to a lot of toy companies, and their answer was, well, we'll make it in China. And I was making it in China. I don't have a problem with that in this case, because it's a commodity product. but that doesn't get you there. It still was taking half an hour to put a pack of balloons together. And to me, that was too much cost and labor. And Zuru is a company that approached me, and it's a family-owned toy company, but they were very ambitious and good at the business. And they said, we'll solve it through automation. And they showed me some of their automation projects, and they understood exactly what needed to be done. So I went out to their headquarters in Hong Kong, and by the time I arrived, they had already designed a preliminary, basically done the design for the equipment that would be required. And I knew enough about the problems that I was able to look at their design, and they really understood the challenges and had a plan to address them. So we did a deal. I had a partner, Zuru, and we went into market. We went and built the factory to go into the market. So it's beautiful, the factory. They put it up in about 7 months. They stood up a factory almost 95% automated. And it's just a beautiful thing for, certain times of the year, 24 hours a day, 7 days a week. My invention's running down this conveyor like a Willy Wonka factory. And it's just a beautiful thing. You put components in this machine and bins, and there's a carousel in the middle, and it matches them up and inserts, and when it gets done, there's a robot that picks it up and does the sealing. So it's amazing what they put together, and it's been a very successful manufacturing campaign. At this point, I had a patent pending. So really important at this point, my understanding was, I need a patent to keep other people from, using my invention without permission. And so I've always been a strong believer in the patent system, and as a way for entrepreneurs and investors and to be able to pursue investment in high risk ventures that you don't know the outcome, and you're going to lose a lot of those. The ones you win that work out, you need a patent to protect your investments. So we can't just come along and steal it. Well, turns out that's not how the patent system works. And I was shocked when, before we even got into the stores, there was a knockoff on TV. It was an exact copy of my invention. We actually found out later in court that they backed my Kickstarter secretly, and I sent them one of my first editions, and they took it apart and changed the green balloons to blue and painted it blue and shot a TV commercial, and they just took off. And I looked into who's behind this, and this company has been around for almost 40 years. There's books written about them. They basically are proud of the fact that they knock off products and flood the market by the millions. And so the Thigh Master, they came out with Thigh Shaper, the Pet Egg, the Spin Mop, the Pocket Hose, those impulse buy items at the checkout aisle. Many of those are Telebrand's products. And so I was going to be the next one. They've been sued over 100 times for patent infringement or related IP, intellectual property issues. They had never lost to a private party. They lost, I think, twice to the government for trade violations or consumer protection issues. Never lost to a private party. And so they were about to steal everything I'd worked for. I went, let me check, yeah. We had to file suit. And so this is where the patent laws come into play. There's no patent police. You have to enforce them through litigation. It became a very involved, expensive, lengthy process. It was not nearly as simple as I thought it would be. There was actually several attempts. So we actually prevailed and won an injunction off of their first version. 3 weeks after the injunction issue, they came out with a slight variation, and the whole thing started all over again. We won a third injunction. We won a second injunction. And then that got even more complicated because at this point the retailers were participating in it. So there was another whole lawsuit. So they ended up with 3 different versions. Year after year, we're in court and trying to survive as a business with these guys, just flat out stealing our technology, blatantly stealing, copying. Ended up with dozens of court cases all over the country. We were in New Jersey and we were in Texas, in my home state. You might have heard of the Eastern District of Texas. It's pretty renowned for adjudicating patent disputes. Well, I was born and raised and started my business and built my production in the Eastern District of Texas. So it was my home state. Halfway through this case, the Supreme Court changed the law and said you can't file suit in your home district anymore. Several of these cases are disputes at the Patent Trial and Appeal Board, which is part of the Patent Office created in 2011 under the American Invents Act. I'll talk about that in just a minute. And then there were, after the lower courts decide an issue, it gets appealed, patents get appealed to the Court of Appeals for the Federal Circuit in Washington, D.C. I've been there 14 times. Basically, if you've heard of like the smartphone wars, Apple versus Samsung, these almost $1 trillion companies. Apple's a $2 trillion company. The same system that they have their disputes and spend tens of millions or hundreds of millions of dollars in litigation. Entrepreneurs have to go through that exact same system. So that's what I was dealing with. Their best defense. So because they copied it, they didn't have. There's basically two defenses to patent infringement. One is we use a different technology, we don't infringe. The other is the patent's invalid, and so they had to go with Plan B because they obviously copied and were dead to rights on infringement. And so here they get to challenge the Patent Office's decision that granted the patent in the first instance. So they will argue that the terms in my patent were vague and indefinite. No one knows when a balloon is substantially filled with water, or you can't tell if balloons are pressing against each other. They actually attempted to bring out as an exhibit at trial a bowling pin, a set of bowling pins. And their argument was going to be, well, when you look at the bowling pins, it looks like they're touching, but they're not. And that was their argument. Fortunately, the judge wasn't buying it. They didn't get to present that to the jury. They argue obviousness is probably the most common and easy way to challenge a patent. And the argument there is it would have been obvious to a person of ordinary skill in the art to combine X, Y, and Z. And so that's the argument. And if they prevail in that argument, your patent's invalid. So they would say, like, if you take this, this older device that someone attempted to produce to fill water balloons, you combine that with a garden sprinkler and another device and a gastrointestinal dietary balloon for weight loss. You just put all these components together, and that's what I was claiming to have invented, and that's obvious. So this was a multi-year, multi-million-dollar legal battle over stuff like this, and we were winning. We were winning preliminary injunctions, which have a really high standard burden of proof, and the courts were working, although they're not accessible to most small businesses. I was fortunate to be able to fund this litigation. But then we ended up in this Patent Trial and Appeal Board, which is a division of the Patent Office that invalidates patents. So since 2012, they've reviewed about 2,800 patents, and they've invalidated 84% of them. So that's the new thing. Patents get invalidated by the Patent Trial and Appeal Board. They actually agreed with these same arguments that failed in a real court with a real judge. At the Patent Trial and Appeal Board, they agreed that the guys down the hall made a mistake, and substantially filled was an improper term, and it's obvious. And so these guys were invalidating my patents and basically basically giving these guys a free pass. So we had a conflict here between the Article 3 court and the PTAB. Running through this nightmare, and this was really scary for us. Everything we had worked for was every day there was a new motion or a new ruling that was just about to sink us. And so many inventors and small businesses, they basically, when you're the rights owner in these cases, you have to win and prevail on every single issue. And the infringer, they've got like hundreds, if not thousands, of different ways they can attack your patent. And if they prevail on one of those, you lose everything and they get to walk away. And so that's what it is, just this volley of, I picture like Braveheart and the volley of arrows. And if one of them strikes, you're done. And so I had 6 patents, actually I have 7 now, 8 PTAB petitions or trials, 13, now 14 visits to the Federal Circuit, ate up a whole bunch of my patent term. We ended up with 29 different attorneys working on this case. Now it's well over 3,000 docket entries, filings consisting of hundreds of thousands of pages, and a $20 million legal bill. Argued all these things. We've been to the Supreme Court as an amicus on things. I almost went there. Lots of really interesting and important legal issues that are captured by this, having an executive branch taking on judicial functions is kind of the root of it, where you've got, a bureaucrat deciding these issues that, implicate separation of powers and Seventh Amendment. Fifth Amendment is now an issue for these. There's takings problems and appointments clause. It's interesting from a legal standpoint, but it's also terrible for an entrepreneur who's trying to run a business. It got so bad, the system wasn't working. I was desperate. I went to Washington, joined some other inventors, and basically to draw attention to the abuse and what I view in many cases is outright corruption. So it was kind of a sad statement. America has, the envy of the world in terms of a patent system and democratizing invention and accessibility for individuals and small businesses. And so here we are protesting it and burning our patents because it gotten that bad. But that actually, they actually made a documentary about this. Let me see here. There it is. And it's called Invalidated. It's on Amazon. It tells us my story and several other inventors who've been through this. And then let me go to the next. I'm going to skip. So what happened? The result of all this was we hung on in court. We were able to pay the attorney's fees. After I went to Washington D.C. in the patent office and the protests, things actually started changing at the PTAB. So I won an appeal. I got my patent back on appeal. They changed director. The director of the patent office was changed during all this. And they changed the judges on my case and issued subsequent decisions that vindicated and upheld my patents. And what happened was after 4.5 years, the bad guys finally realized that I was surviving and I wasn't going away, and it was costing them tens of millions of dollars to try to get away with stealing my invention. And so basically they surrendered. So in spring of 2019, they had a jury verdict that was due and they were going to have to post a bond to appeal. They had 2 more trials that were pending, and they said, we give up, we'll settle. And it was, that I made them pay that. We had a jury verdict. One of these went all the way to jury verdict, and the judge doubled it for willfulness and added on attorney's fees for frivolous motions. So they owed us $31 million. And of course they wanted to vacate that decision and settle and make it confidential. I said, no, you put me through all this. This is going, I'm going to have to speak about this someday to some university or something, who knows? And so that's official. And then there was an additional payment to resolve the other infringing issues. And now when I had to come to Washington, an organization called US Inventor helped me, showed me, which committees write the patent laws and who to talk to. And it's a fledgling group of mostly volunteer inventors with limited resources. And I've gotten involved, and now I've met hundreds of other inventors and entrepreneurs who just are getting steamrolled by a system that's very unjust and unfair. And so I now volunteer full-time with US Inventor, advocating in the courts and at the patent office and then the legislature for basically returning to kind of our traditional democratic merit-based patent system where, anyone who comes up with a new and useful and non-obvious idea can enjoy exclusive rights to that and build a business on it and so forth. So it's a very important, busy task, and I'm happy to be doing it and happy to share with you. And I'll turn it back over to David.
All right, Josh, thanks. Yeah, very interesting story. And so as we begin the question and answer session, we got plenty of time here. Let me just encourage everybody who's attending, if you want to ask a question, I've already got several lined up here, but use that Q&A function at the bottom of your screen. You can type in a question. We'll review that and ask some questions. But Josh, let me ask some of my own questions first as we start the Q&A. We have business students, we have engineering students, and we have law students all joining in to hear your story, because your story touches on every area. Let's start with the engineering students. And what advice do you have to an engineering student? They're learning a lot of concepts in college. They're looking toward their future. They're thinking, wow, a job with TI. But they're also thinking, wow, create your own inventions. When did you know it was time to leave TI? And I'm sure it wasn't a safe decision, but what advice do you have for engineering students who are thinking about that?
Engineering's much more diverse than I think a lot of people think. I'm more of in terms of the box, right? There's engineers that are just really, and it's really important. Like they follow the procedures. They rely on the basics and the foundations that have been created and the principles and laws that are, well established. And that's important. If you're launching a space shuttle, you don't want to get crazy. And then I'm kind of the other end of the spectrum where I'm almost a skeptic to begin with. Like, why do we do it this way? Is this convention? Why do we have to go with convention? Isn't there a better way? So, kind of know your lane. And there's definitely, engineering, STEM fields are really, really in high demand. They're important, and it's not going away. So pursue that. And then, the entrepreneur thing it's not for the faint of heart, and it comes with a lot of risk. For me, it was knowing our limits, and we were pretty strict about it. As I mentioned, when we kind of got to the end of the rope there with a bunch of balloons, we went a little deeper than we had intended in terms of our savings, and but kind of know your limits and work within your skill set. Yeah.
So I guess a follow-up question relates to your story of invention. We'll get to the funding kind of next, but in terms of coming up with the invention, you described, I think, a eureka moment. Would you describe the overall process of conceiving the idea and really figuring out how it would work? Was it a eureka moment? Was it a series of attempts and failure and then changing and failure again? Was it more of a process, or was it that one aha moment?
The first stage was when it hit me that there must be a better way to do this. There's just some things that you just know that this cannot be the end point for this problem. And filling and tying water balloons one at a time, I just knew there was a better way to do it. And it's interesting, and I viewed it as my job to find it. And I actually didn't learn until much later that in the Constitution, our founders refer to inventions as discoveries. And so I actually viewed that as my job to discover this solution. And so that was it. When I knew there had to be a better way, that was the key. And then at that point, it was just a matter of allocating, time and devotion to finding it. So it would be something I would tinker with off and on, usually in the summer when it became, kind of a pressing issue. I would work on it for a while. And then I tried all sorts of things. I was putting objects in the balloon to try to stop the neck of the balloon. Turns out mini marshmallows were the best solution for that. I was looking for something that was biodegradable and soft. And that actually, it worked to some extent, but I wasn't satisfied. It didn't fully solve the problem. I tried some other techniques, and then I just kind of latched on to this idea of a small enough elastic ring. Ended up you know, I ended up with an O-ring with like a less than a 1 millimeter inner diameter. So the challenge there is you got to expand it big enough to get it around the balloon and the tube, but then it's got to be able to shrink down small enough to still clinch that the neck of that balloon shut. And so I just latched onto that and worked through it. And then the other piece came when I realized it could be done in large numbers simultaneously. And that one just was more of a stumbled upon when I said, you know, my tube was already small enough that there was room for others. So it just kind of, a lot of times you end up going a different direction than you start out on these things.
Very interesting. So once you had the invention in mind, right, getting to market's a completely different activity. So did you actually have a business plan? Did you write out a business plan? And if you did, like, what was your business plan?
I wrote a business plan with my first invention, but it was I don't think it's a plan like we think about. It's a process of working through. And because for me, my first business plan was constantly being updated and improved, and kind of for a while it went in the direction of being a pitch, an investor pitch. And then, but what it really is working out, you know, what's going to turn this into a product, how are you going to get there? And with bunch of balloons, it was more flying by the seat of my pants. Like I knew I had a challenge with the cost of goods. And so, you know, I was aiming for a certain price point, basically $10 a pack. And I thought people might be willing to pay that for it. And everything else kind of just like, it was either it was because of experience or intuition or combination. My other experience was, you know, I push things ahead as far as I can. So it's nice when it's something low tech where I can afford to, it's easier to raise funding. The digital paper cutter was harder because it was, you know, a lot of moving electronic components, a lot of tooling. But even there, I was able to, you know, with angel investing, friends and family, get to the point where I could prove out the value of the product. So I'll try to get it to first base, but I'm ready to hand it off as soon as I find a partner that sees the value. So that's kind of I go down plan A is to license, plan B is to go into production for me and build a business. And if I believe in it and I can afford to go down plan B, I will, up until I find a partner.
So you get the $1 million, almost $1 million, through Kickstarter, and you didn't expect to have that much. What were you originally planning to use that money on? And then you came into almost $1 million. And then, so how did you spend that money? Your business plan changed at that point, I take it.
We actually were prepared to scale to up to $1 million, but we officially asked for 10,000. That was more strategic. I was, you know, I felt like I needed to raise 100,000 to really get the business rolling. And so it just goes into tooling and basically it just went into production. And we burned through it because we had to pay for molding, tools. We had to pay for a lot of upfront costs that you maybe don't think about. In one instance, you know, I think we had to rework or even dispose of about 20,000 units that were defective because we're still working out the bugs. And so those sort of costs consumed pretty much all of the $1 million. So, but it was enough to get, you know, we shipped 100,000 units too. And so we were in business, but usually you don't return a profit. No, I don't know. Kickstarter, crowdsource, unless you're super experienced and have a very specific business plan, those usually aren't profitable for the project.
All right, now as we think about kind of the law students, right? You've got, I think, 6 or 7 patents now. You've been through the process of obtaining patents several times, but you've also gone through the process of litigating them, you know, withstanding challenges. As you think about what you've learned through the litigation, you know, as you think about a student who's thinking about representing inventors and drafting patent applications, what advice do you have for them in terms of working with an inventor and getting their first patent application on file, for example, but doing the best job that they can to represent the interests of the individual inventor?
Well, that's really hard right now. I think it's a dilemma for patent attorneys because, and they learn, a lot of them learn this. The ones that have seen what I go through, they learn this, is that independent inventors and small businesses have no business participating in the patent system. I mean, the question should be, do you have a $20 million credit line in case you have to go use this patent? And the answer is no. And so then you're like, do you even start down that path? And so I would first of all say, I can't take your money. I'm going to go find a large corporation to work for, or an investment firm that wants to prosecute patents. So that would be my first advice: is don't mislead the client into thinking that a patent's going to protect him. If he's well, if he's well advised and he's determined that he wants a patent, then have a really good disclosure. That initial disclosure is all you get. Ours was pretty thin. Mine was only about 3 or 4 pages with maybe 8 drawings. And so we barely had enough disclosure in order to cover the whole scope of my invention. So that disclosure's got to be, it's got to be wide, it's got to be deep. And I think there's a lot more creative ways to do the disclosure and pull in what is the state of the art by incorporation by reference. So you really want the really broad disclosure and really deep disclosure, because after that you lock in the invention. And the second key is to always keep a continuation application open. So even when they issue a patent, usually never is the first patent going to perfectly cover the full scope of the invention. So you're going to get some claims for part of the invention, but you're leaving all this other scope unprotected. So then you can come back and get another patent. Even on a simple invention like this, because it was so valuable, I now have 7 patents that cover it. But you don't have to do all that up front. You don't have to have any patent at all. If you have a priority date and you're continuing prosecution, you're protecting the client right there, because you can always come back and get claims allowed if they need a patent. So, and I always have one pending, and always in a state where I can get an allowance and an issuance within a few months. So as this was going, they would come up with some new trick or invalidate a patent. I was able to come around and get a new patent to plug any gaps within a matter of months.
Okay, then a follow-up question now related to litigation, right? So I know you're very critical of the Patent Trial and Appeal Board. So I want to reserve that discussion, but focus on the Article 3 court, Article 3 under the Constitution, the federal district court, and then it goes up to the federal circuit, the Supreme Court. So you're in what we call real court. Some people would call real court, real judges, so to speak, at least nominated by the president, confirmed by the Senate in the federal system. So you went through that system. What advice, and you worked with, you said, many attorneys. What worked well in litigation in terms of representing the patent owner plaintiff? What did not work as well?
You have to spend a lot of money, file a lot of motions, and you have to be more aggressive or equally aggressive as the other side. I find a lot of attorneys will take a case on contingency now, and they think if they file a complaint that's going to scare the other side into coming to the table. And then they find out, oh, they just filed a motion to transfer, a motion to dismiss, a subpoena, there's discovery, and before you know it, you're in this $5 million litigation just to get to a jury trial. And so it's serious, it's outrageous. It should not cost that much. There should not be that many motions. I mean, maybe some cases are super complicated, but not my water balloons. But anyway, that's the challenge is you're playing for keeps, and maybe the other guys has fewer, the same amount of resources as you, and so neither one of you wants to go nuclear, and you're just I don't know why you're litigating if that's the case. It's no holds barred, winner take all.
Well, let me then last question before we go to the questions we received from the audience, but the Patent Trial and Appeal Board, you're very critical of it. U.S. Inventor, you're working hard to try to represent the interests of independent inventors. What is U.S. Inventor doing to represent the interests of just the individual people who, like you, came up with a great idea, sought patent protection, they get a patent, and they're worried about infringement, and maybe there are infringers. What positions are you guys taking, and what are you doing?
Well, the idea of the PTAB was just misguided. So the thought was we could get an expert, to decide these cases, but we have a judicial branch for a reason. These aren't really technical disputes. They're legal disputes over property rights. And so we've basically taken and we hoped that, a technologist would be able to accurately and efficiently resolve these issues. And what we found instead is that you take basically people who have very little technical experience, very little legal experience, and are willing to work for a very low salary for the government, are deciding, the future of these businesses. And it's trillions of dollars in assets that you're handing off to really the least qualified and potentially corruptible people to decide it, to where now every election, there's an election right now. And I tell you, Silicon Valley is donating millions of dollars to both the Trump campaign and the Biden campaign. And whichever one wins, they're going to go, and they're probably leaning more towards Biden right now, because Trump's guy has been much more measured and fair. And so if Biden wins the election, they're going to get to choose the new director of the patent office and all the policies that affect our patents in 2021. So all the work I've done the last 3 years to, slightly move the ball towards leveling the playing field, they'll undo that in the next election. So it's introduced this huge political influence element to deciding what, up until very recently, were essentially property rights.
All right, so let me go to some of the questions from the audience. And so I'm going to ask some of these in kind of rapid fire. I think that some of them are rapid fire type questions, right? How long did it take for you to get your first patent from the time you filed it?
9 months. It was on fast track.
Wow, that is fast. Were those your kids in the video?
Yes.
What jurisdictions do your patents cover? Are they all US patents? Do you have any foreign patents?
We're in about 30 different jurisdictions. It's a global product, and the U.S. has been our biggest market, but we have substantial markets worldwide. The nice thing is it's a seasonal product, but when it's winter here, it's summer in Australia, New Zealand, and South America. So we've got a year-round market.
Next question. I think you may have answered this, but how did you fund the litigation?
Yeah, that's important. My partner Zuru had a little bit of experience in litigation and had some capital reserves to seed fund the litigation. So we hired a small, nimble, aggressive team, and then we added to it as we went. And we were very fortunate that we were able to sell a lot of product and compete with these guys. So the key here is we were able to compete without effective patents. And by competing without effective patents, we were able to generate enough revenue to go back and fight and win our patents. And so that chicken and egg conundrum, we were very fortunate to be able to sell hundreds of millions of dollars in water balloons in order to pay these legal bills.
And I think you mentioned this, but just to clarify, because someone asked, what were the total legal costs associated with all of your work?
We were $20 million. That's
right.
Mostly attorney fees. Experts are very expensive. And there's quite a few other expenses. And yeah.
Okay. A couple of questions that are similar. How would you modify patent law? I think one thing you're critical of is the Patent Trial and Appeal Board. So maybe if you, besides that, because clearly you view that as a problem. Besides that, what else would you change in the system to make it work better?
We kind of have short-term goals that are, various ways to get more reliability at the time of issuance. I think it's really important that we structure our patent system, and we did for 200 years. Once a patent was issued, the patent office would not review it. And so with all these opportunities to review a patent after it's issued, it's like giving a professional golfer a mulligan, not on the first hole, but on every hole. And so, it's like, why, it doesn't matter if you get it right the first time, because now we're adjudicating them afterwards and inside the same agency. So anything we can do to, even if it means issuing fewer patents or increasing the cost of patents. Originally, our idea was we want the cost of patents to be lower, at least than in other jurisdictions, in order to make the patent system more accessible. But you can't throw out reliability because when they're not reliable, you're basically increasing the cost to get a patent because it's going to be disputed for many years. And so anything we can do to get it right the first time with a much higher confidence level is what we need to be doing. And as an investor, that's what, people come to me with their, now that they see that we've come out the other side of this, now I'm an angel investor. And when they come to me with a product or a concept or a business, I'm like, well, then what's the collateral for my investment? And if they say it's a patent, I say, I'm sorry, that's not going to, it's not going to cover me.
All right, next question. Were you able to use your mechanical engineering background to help with manufacturing your inventions?
Yes, I design for manufacturing is really important, and and you can learn this too. I learned electrical engineering, I learned some programming, and I learned law for all. My gosh, so you can learn these things, and I like to, when I do outsource things and hire people and consultants, I like to bring on people that will teach me how to do their job, and so that I can understand how they're doing it and what their game plan is. And so being you don't have to be a mechanical engineer, but if you outsource the project to a mechanical engineer, it may not meet these overall goals for the project that you understand better than he does over in the design silo.
All right, another question. Are you hoping to invent another product that kids would enjoy? Are you still inventing?
Yeah, I'm actually much broader than just toys. I've got ideas and concepts for, energy efficiency and, water purification and transportation. And I'd love to, Elon Musk type things. I'd love to get involved in more grandiose and important missions. And what I've decided though is right now, as a result of what I've gone through, I have a platform to communicate to policymakers that no one else has. Like, it's very unique. And so, yes, with my resources and experience, my one brain could go work on solving more problems, but I get much more leverage by using, this opportunity to expand access to the patent system and to innovation to others, so we can have hundreds of thousands of creative, ingenious brains working on these problems and infusing them with capital investment, which has gotten really hard in this environment to fund diverse, high-risk ventures. So that's my best way to contribute to innovation right now.
All right. So there's a lot. I got a couple of questions related to so-called patent trolls. So there's this narrative out there that patent trolls are a significant problem in the patent system. Did you have any run-ins with so-called patent trolls? What's your response to that narrative and that critique of the patent system?
Well, there's abusive litigation in every field on every side. Okay, and so Silicon Valley took abusive litigants in the field of patents on the side of plaintiffs and turned that into lobbying and a policy to wreck the patent system for everyone. And because that's their benefit. So this is where large technology corporations who have no problem fighting off a patent troll in a regular court, no problem at all. I mean, they've got a $1 trillion market cap now, hundreds of billions of dollars in cash, and it takes 10 years or more to litigate these things, and they're not going away. I mean, Telebrands is only $1 billion company, so they couldn't last 10 years. But I guarantee you, Apple and Google and these giant tech companies, they don't settle unless it's for pennies on the dollar. And so, yeah, patent trolls are no different than class action lawyers, or defendants are abusing the system much more. You look at the motions that they're filing and that they get away with. So basically, they've taken that narrative and they've changed the law at the Supreme Court, and they've changed the law on these post-grant proceedings so that they don't help any small businesses. So allegedly, patent trolls threaten small businesses. Well, you know what? They've gotten no relief. And so right now everyone's lobbying. They're lobbying, to preserve this system because it's starting to work finally, and it only helps big incumbent monopolistic corporations who are not threatened by patent trolls. And now it's made it harder for legitimate entrepreneurs to participate.
All right, well, on that kind of sad note, I guess, but our time is up. So with that, let me thank you, Josh, for your presentation today. Thank you to our audience for joining us. To stay up to date on upcoming Tsai Center events, follow us on Twitter at SMU Tsai Center and look for our future emails. Until next time, take care. Thanks.
Thank you.